My name is Janson Wu, and I'm the Executive Director of Gay and Lesbian Advocates and Defenders GLAAD in Boston. The Lawrence v. Texas case is a case that was seeking to overturn a law in Texas that criminalized same-sex intimate conduct. Basically, in effect, it made our relationships and our identities criminal. And I just wanted to really underscore how damaging that was for LGBT people in this country at that time. When you are deemed a criminal simply because of who you are and who you love by the government, it means that it is so much harder to create a family, to be a parent, to get a job as a teacher, to receive protections from discrimination. It was one of the biggest barriers that we had in our movement to advancing the rights of LGBTQ individuals. So this was a high priority for the LGBT movement at the time, was to make it unconstitutional to criminalize LGBT people in this country. What I remember was this enormous feeling of excitement and worry. We hadn't been back in front of the U.S. Supreme Court in a long time on a gay case. The last time we were there, we lost. It was a case exactly like Lawrence v. Texas. It was the Bowers v. Hardwick case. And in that case, in 1986, the U.S. Supreme Court actually upheld the law criminalizing our relationships. It was a horrible defeat for us. This is the risk that you take when you bring a case up to the U.S. Supreme Court. And so we were very careful about the timing to come back to try to overrule the Bowers v. Hardwick case. Finally, when the Lawrence v. Texas case went up a little over 15 years later, we felt the time was right and that the court was ready. But we weren't sure. So I remember waiting in line and having lots of conversations with folks in line. Most of them were our supporters, but not all of them. And everyone just had this sense that this was really a moment in history, either direction. And we all felt really lucky to be a part of that. The next morning, since we were at the front of the line, we got our first pick of seats, which was still pretty far back because a lot of the seats are reserved for special guests, the justices, as well as for lawyers. But I remember being surprised how small the courtroom actually is. And just really what impressive space it is as well, too. I mean, this is the highest court in our country, and it commands a lot of respect when you walk into those doors. Speaking to a lot of the attorneys and activists who've been doing this for many, many years afterwards, it was very profound to hear what a difference 15 years makes. From when Bowers v. Hardwick was argued, when our movement didn't even feel comfortable having an openly LGBT person argue the case, and instead we asked a straight ally, law professor at Harvard Law School, Larry Tribe, to argue it, to the point now in 2003 where not only did we have an openly gay attorney, Paul Smith, argue the case for us, but if you looked around the courtroom, it was full of openly gay individuals and lawyers. And that is profoundly powerful in swaying the court, to look out to the people that they are talking to and understand that these people are just like them, and that they are profoundly impacted and harmed by these laws. We heard the news that the U.S. Supreme Court had weighed in our favor, and it was just an incredible moment, particularly for someone like myself who was just starting my career as a lawyer, who wanted to go into some type of social justice work, understanding what a powerful tool the law can be in changing our country and our society.